All right. Hey, it's Jack from Jack Gately Real Estate and the Online Real Estate Academy, and we have a lot of news. It is Friday night, June 21st. I knew that this was going to be a big week in these lawsuit things, and I've been waiting for the other shoe to drop, and we actually got two shoes to drop late today. And coast to coast, we have news on this very important and developing story in the real estate industry. So, out of California, we have the Department of Justice launching a formal inquiry, to quote realestatenews.com, into the forms that the Department of Justice, that the California Association of Realtors was about to issue that would have theoretically been their response to the NAR settlement. This appears to be an attack on the concession model, the seller concession model that CAR rolled out 2 or 3 weeks ago, right, along with some other MLSs. So they were basically saying that we're not going to have traditional sharing, we'll have seller concessions, and that will keep us out of trouble, right? That was kind of the theory out of CAR. Remember, Ed Zorn from CAR is one of the biggest thought leaders in the industry, and he was basically I think that was kind of like a shell game, right? We won't do traditional cooperating commission, but we're going to do seller concessions. Completely different. I think when Bright MLS issued their guidelines and they were so defensive about it relative to seller concessions, you understood that it was just a shell game. So we're going to get into that story. And also tonight, we have a new statement of interest. Joint statement. We have a joint statement. I didn't think we were going to get a joint statement, but we have a joint statement from MLS Pin, the plaintiffs in the MLS Pin case, and the Department of Justice. But I got to tell you right off the bat, we're going to get into the details on this one as well. Right off the bat, this might be a joint statement, but there's not a lot of agreement. The plaintiffs and the defendants, known as the settling parties, they seem to be in agreement, but the Department of Justice is not in agreement. So it's one piece of it's one document with two very different messages, two distinctly different messages in that joint statement. So it's not let's all get around the campfire and sing Kumbaya. No. It's all one letter, but it's two distinctly different. We're going to get into the details on that. Remember, the Department of Justice has been, how do I want to say this, on a tear recently. Let me just turn down the volume here on the you're trying to run a business here. There we go. The Department of Justice has been on a little bit of a tear recently. If you haven't noticed, took some notes. They've now made a new comment on the Rex Zillow lawsuits. They're basically saying Rex should get a do-over effectively. They're trying to reopen the NAR investigation. They launched an investigation into RealPage, which we've covered on this channel before. And that's about fixing of apartment rentals in the rent that you pay in an apartment by big. There's a whole big. Do I want to say cabal? We'll stipulate cabal. There's a bunch of big companies that could be involved in that lawsuit. So hey, thank you so much for joining us today. Bushy Top, great to have you here. Great to have you here tonight, Bushy Top. All right, so the Department of Justice, they're on a tear. You can definitely see that. So let's take the California story first. And I want to thank you all for joining us this evening, Friday night. I was going to do this video tomorrow morning because I'm more like a morning guy, but actually going to NASCAR in New Hampshire tomorrow, going to be up and out at dark 30. So let's just bang this out while we're here tonight, right? And let's bring up the real estate news story from Stephanie Reed Simmons that was published, I believe, late this afternoon. DOJ Oh, that's the wrong story. I didn't want that one. Hold on a second. There we go here. DOJ formal inquiry delays release of car forms. So California Association of Realtors, if I'm not mistaken, is like the second largest in the country. The California Association informed members that the Department of Justice expressed concern over the new forms related to the NAR settlement and MLS practices. That's not good. Amy Fisher, by the way, the author of this article. The Department of Justice continues to bear down on the real estate. Well, I actually just mentioned that. The scrutiny now is focused on CAR, and they're notifying members today that the organization has delayed its planned release of 21 forms following a formal inquiry from the Department of Justice. I'm just guessing that nobody really wants to be on the receiving end of a formal inquiry from the Department of Justice. That seems like it might ruin your weekend. Yeah, I'm guessing Mr. Zorn, who's definitely been a thought leader on this, thoughtful, not that I necessarily agree with everything he says, but he's been the leader. Not that I agree with it, but I'm guessing he's having a difficult weekend. What are the forms related to? In accordance with the NAR policy changes effective August 17th, we'll see if that actually happens. Notably, the requirement that MLSs remove offers of compensation fields from their platforms. MLSs have been working to update their systems, forms, member resources, blah, 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 blah. This year, 21 of the 67 forms were expected to be released on the 25th, which would be, early next week, were related to the NAR settlement and its impact upon the MLS practices. Now, I don't know why they don't interject right here that California Association has been one of the biggest leaders, basically, of doing this concession model. I don't know why they don't mention that, but I think they should. And the Associated California MLS has been that, right? The California, okay, could there be a different MLS and the California Association? Yeah, there is a difference. Is there a substantive difference? Yeah, I guess so, but effectively not so much, right? One is influenced by the other. I see this here in Massachusetts as well, as I just may say. MLS Pin is broker owned. It's not owned by NAR. And in fact, NAR is not a party to the MLS Pin Nosalek case. But MLS Pin is strongly realtor influenced. The vast majority of the members of MLS Pin, subscribers, of which I am one, are realtors. I am not a realtor, but I believe that the vast majority of MLS Pin subscribers are. So to say these are separate organizations, yes, but are they really? Not really. It's all the same big real estate, right? That's how I look at it. So the forms in question allow listing brokers and buyer brokers to share commission information that ultimately results in an offer of compensation that would likely invite the attention of the Department of Justice, suggested an industry expert who asked not to be identified. In other words, the forms were probably related to the concession fields that were suggested, that was like 2 weeks ago or something. I think that's what they're trying to say. In the MLS Pin case, the Department of Justice voiced clear objections to commission sharing. As long as sellers can make buyer broker commission offers, they will continually offer customary commissions out of fear that buyer brokers will stay away from listings with lower commissions, a well-documented phenomenon known as steering. So, if you're starting to get the sense that your worlds are colliding between your bombshell commission lawsuit in Kansas City, what's happening in California, and your Massachusetts-based Nosalek MLS Pin case, you're starting to get it. Some of us figured that out many months ago, that these things were on a colliding path. That, in fact, the substance of the NAR settlement is different than the substance of the MLS Pin Nosalek settlement. Right? So how can you have a separate set of rules for Massachusetts when you also have most of the people that are MLS Pin subscribers are NAR members. Like, yeah, that doesn't work. That doesn't work. Oh, let's go back to real estate news. Carr did not indicate what concerns the DOJ raised, but the organization is delaying the release of forms to review not just the NAR settlement, but also the Department of Justice statements relative to the industry. What Carr had to say, President Melanie Barker wrote, "We are in the midst of significant changes, and as such, there will be times when we have to adjust our plans, our timeframes, and our expectations." Yeah, it's a moving target. And I think that this is kind of the Department of Justice attacking the whole concept of seller concessions, right? So that's my take on it. I would love your comments, by the way. If you want to add on some comments here, let's check it out, because in a second, we're going to take a look at the joint statement from the Department of Justice, the MLS Pin plaintiffs, and the MLS Pin defendants, which is MLS Pin itself. So we're going to stop here, pause here. We're going to take a look at your comments, and then we're going to take a look at the second half of this video, which is that joint statement. So let's take a look at your comments first. Bushy Top, it's like the difference between a super PAC and a candidate, essentially the same thing. Yeah, so that's a good example that there's not coordination. There's never coordination between the super PAC and the candidate. No, never coordination between those two. Okay, good, a good analogy. I like that. Okay. I'm from Carr. Oh, welcome from California. Thank you so much. I'm a Carr forms trainer for over 20 plus years, and as soon as I saw them, I knew that there would be issues. Why with One Stop TC? Hey, thanks for being with us from California. Sorry, I almost feel sorry that I put your comment up, because I don't want you to get in trouble in California. So I'm glad you're here. I agree with Jack. Well, thank you, William. The seller's concessions are being viewed by the Department of Justice, just like you suggested. All right. And also, are the attacks on the real estate industry going to end? It does not look like it. Right. I mean, I think there is definitely a politics point of view. It's good politics right now to beat up on greedy real estate agents, right? Didn't we have the current president actually said that real estate agents should lower their commission? Didn't we even, I'm not mistaken, I think I heard that. And I mean, housing affordability is an issue nationwide. And if you're running, especially if you're running for re-election, it's easy to beat up on your average real estate agent, right? Than to take the blame yourself for Federal Reserve policy, for instance, or for inflation. Elizabeth Warren. Sorry, trying not to make it too political, but hey, what can you? I can't help myself. So yeah, much easier to beat up on greedy real estate agents. So good point there. By the way, well, maybe we should go live more often on a Friday night, because we have a good showing today. Mark B says Department of Justice will get their way. You kind of gotta believe that they have the upper hand. I mean, they do. It is like theoretically, Mark, it is like the Department of Justice, basically the largest, most well-funded law firm in the world ever, right? Our industry should just embrace it and become creative to new ways to earn income. Too much real estate drama. Oh my God, yes, triple that. Yes, totally endorse that. Yes, I love that comment. Thank you. Find creative ways to make money in this business. Now, I did put a link in the description to this real estate news article. I subscribe to them. If I would consider you subscribing them as well. I think it's worthy. If you're watching this video, I think you might consider subscribing to them. But the link is in the description of this video. For free, because I'm such a nice guy, I downloaded the joint statement from the MLS Pin case, and that is also in the description, but that's free. There's no charge for that. And you can get that. It's a Google document, And let's bring it up on the screen right now. So here in this document, which we're not going to go over all the legal mumbo jumbo in this document. Remember, I'm not a lawyer, too smart to go to law school. I actually like to get things done. So I read it for you, and I'm just going to give you some of my interpretation. We might cut into it for a couple of juicy quotes. But again, there's a Google link in the description of this video. So if you want to download it. Oh, by the way, I think I posted it in a way that you don't have to ask for permission. You just click the link, I think. Because last time I did it, you had to ask for permission. It was a pain in the ass. Now I think I did it a little bit more streamlined. All right. So what is this joint statement? What is this joint statement, which is not much of a joint statement? What is this? It says joint statement at the top of the page. It's not much of a joint statement. What does it mean? Well, the settling parties, which are, again, the plaintiffs and the defendants, in which case it's basically Nosalek et al. Versus MLS Pin et al. The settling parties are proposing a particular schedule. And basically, they're saying this should be the schedule. And if the Department of Justice doesn't like it, they're free to file a lawsuit whenever they want, right? That's what the settling parties are saying. They do not agree with the Department of Justice assertion. Did I pronounce that right? Assertion, excuse me, that the settlement, quote, raises serious antitrust concerns. I think it's important to note as well that this is the third version of the proposed settlement. And I think one of the concerns here, writ large, is that the Department of Justice wants to make sure that there's not a fourth version. And the settling parties do not agree with the Department of Justice that they should delay this settlement until Judge Bowe acts on the NAR settlement, which is not due until November 26th, which is, I'm guessing, right around Thanksgiving. And the settling parties assert that any type of delay in the MLS Pin settlement would cause a disruption to MLS Pin subscribers, as of which I told you I am one of them. And I am also not a realtor. But as I've said many times, more than anything, what I want for my industry is a clear set of rules that I can depend upon. Like Mark just said, there's a lot of opportunity. And the more the cookie gets crumbled and smushed up, the more crumbs and the happier I am. Because am I a real estate broker? Yes. But why am I a real estate broker? Because myself, I like to think of it myself as I'm like a solo entrepreneur. What is my real mission in life? To make money. How do I make money? By adding value to people in society. That does not lock me into doing that in just one way. It allows me to think a little bit more creatively to make money. And when you think more creatively, you solve problems in different ways. You add more value, and you can do very well that way, right? So let's go on to the other side of the coin here I think this is the beefier part when we get to the Department of Justice's position, which is starting on page 6 of this so-called joint statement. I got brand new glasses. I'm blind as a bat, so let's see if I can read this. The proposed settlement in this matter has been revised and or amended on multiple occasions, and the entirety of this agreement has not yet been disclosed to the United States. Well, that kind of knocked my socks off right there. I can't believe this. So we are now on the third version of the settlement, and the Department of Justice is asserting that they have not seen the full settlement, which I'm like shocked by that. The United States respectfully requests sufficient opportunity, at least 60 days, which someone check my calendar. I'm pretty sure August 17th is less than 60 days from now. I'm pretty sure of that. To review and comment on the final proposed third amended settlement. The United States understands that the court may wish to stay this matter pending final approval of the Bombshell Commission lawsuit out in Kansas City. Now, you got to kind of understand some lawyer stuff here. When the Department of Justice writes something like that, the U.S. understands the court may wish. That means the Department of Justice is asking the court to do that. That's just kind of a nice lawyer way to ask you to delay it. That's what they mean by that. In the interest of judicial economy. The interest of judicial economy. Okay. Or allow the United States to submit a statement in connection with the final approval rather than the preliminary approval. So then we get into this big argument, which we will not detail. If you're a lawyer and you want to go read that, go right ahead. Or if you can't sleep tonight, you can go do it. But they get into this big argument basically saying, we think that we, the Department of Justice, should be allowed to comment on the proposed settlement once you give it a preliminary approval. But we should not be pigeonholed into commenting on it now before you even give it a preliminary approval. The Department of Justice is saying, hey, why don't you give it preliminary approval first and then we'll comment? Not the other way around. Because what I think the Department of Justice is concerned about, if they're forced to make a statement now, how do they know it doesn't go to a fourth version of the settlement? And furthermore, they haven't even gotten a copy of the full third proposed settlement. So let's go to the money quote, which is on page 8. They also have a calendar of proposed events, which is slightly different, I think, than the plaintiffs / settling parties proposal. So here's the money quote. After the plaintiffs in this case filed their first settlement agreement, the United States filed notice flagging the proposed settlement agreement as raising significant concerns. Then after several exchanges with the court granted the United States 60 days to file a statement of interest, which they did on February 15th. Some of you might remember, if you've been watching my channel for a long time, I did a live stream about that from Florida, the free state of Florida, when I was down there enjoying the Daytona 500 and other things. The United States submitted a statement of interest in that matter, explaining, and here is the money quote, merely authorizing sellers to offer $0 commissions as the Nosalek settlement did perpetuates the same commission setting system and therefore raises serious antitrust concerns that may independently violate the law. Dun, 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 dun. Right? Oh my God. Since February, the parties have modified their settlement agreement but have not yet moved for preliminary approval. And their revised settlement does not include distribution methodology, blah, blah, blah. So basically they're saying, as they said in February, that the Nosalek settlement is problematic. And they're also saying, going back to the first part of this video, that the concession solution is also problematic. All right, so let's cut now here to see if we have any other questions. Bushy top. I think once alternative models become more mainstream for representation, more internet-based and more affordable, things may calm down. Right, you may see flattening of buyer representation. I think they do. I think we will. And I think that will be an opportunity for some people who will embrace that. You might think about that. Buyer's agent flat fee loading, Prime Cash says. Bushy, I've read a lot of your comments, Bushy. All right, I'll read one more. Percentage-based models don't necessarily make sense on the buyer side, especially if there's a zero difference on the amount of work a buyer's agent will perform. So basically what Bushy Top is suggesting is that, and I think this only really works in a seller's market where the buyer can find the property basically on their own by going to open houses, for instance. If the buyer can find the property on their own, then you could have an agent sitting in a nice air-conditioned office or heated office that never actually goes to the property and represents the buyer in the negotiation, but how do I want to say this? Doesn't physically leave their cubicle, yet still represents the buyer on the nitty-gritty of the deal, getting the best deal they can, basically doing the negotiation. So yeah, I think that's a potential business model out there. We'll have to keep an open mind. But again, if you approach this as a real estate agent or a real estate broker, you're thinking about it the wrong way. The way you need to approach this as a real estate entrepreneur. If you're a real estate industry entrepreneur, you're looking at this whole thing the right way. If you're thinking about this as a real estate agent or a real estate broker, you're kind of constricting your options. All right, excellent comments there. The present dispute. Hold on, let me just check my notes and see if I missed anything here. No. All right. So, by the way, they're also requesting, this is one thing I want to mention. They're also requesting any potential confidential side agreements to the settlement. So the department is pissed off that they have not received the full third proposed settlement. And now the department is suggesting that there might be some side agreements that they also haven't seen. So they're a little pissed off about that as well. All right, let's go to the present dispute, which is actually the last substantive page of this, even though it's 20 pages. It's the last substantive page. Blind isn't bad here with new glasses. Let's see if I can read this. The United States has been involved in the United States appreciates that they do not want to hazard the cost of providing notice to the class. So yeah, they understand they don't want to incur costs by having to send letters to all the potential recipients of, that are going to get like 83 cents out of this deal. But if the parties want to solicit and litigate United States position on the revised settlement at the preliminary approval stage, as opposed to the final approval, the United States needs substantial time to respond. Indeed, while trying to truncate the United States time to respond to their latest settlement agreement, the parties have demonstrated no urgency in waiting over 4 months to renew their motion for preliminary approval after the United States' original statement of interest. So this gets into a long legal argument, like it's basically, you're the one that's delaying it. No, you're delaying it. No, you're delaying it. No, and we all know that all the lawyers are all delaying it because that's what lawyers are good at, right? They're good at delaying things no matter what. So you get the sense that everything would have been better if this multi-district litigation panel had taken this all up as one thing, which I was a big fan of, but I was kind of disappointed that didn't happen because, again, as a person in this business, I just want one set of rules that I can depend upon so that I can go out and make business decisions. And since that didn't happen, now we have competing settlements, and now we also have competing solutions, seller concessions, and now it's a complete foobar, right? Absolutely. So my advice to you going forward, remember, not a lawyer, so you go seek your own legal advice or whatever, but no more agency to agency compensation, no more of that, and no more suggesting through either a written text in the listing description or through seller concessions, or no offering that the seller might pay a concession or a commission. You shouldn't do that. If the buyer wants to ask for the listing, ask for the seller, let me make sure I get this right. If the buyer wants to ask for the seller to pay the buyer side commission as part of their offer, that's fine. In fact, the Department of Justice says that in page 21 of their February 15th statement. But you, as the list agent and or seller, should not make an offer of that commission, and I don't think you should even mention that you're willing to entertain it. Just list the property and then see if buyer agents ask for a part of the fee. Buyer agents might not ask for a part of the fee, or they might. I think it's going to be on a property basis based upon the marketplace. And going back to what I said, like starting like 2 years ago or whatever, this is going to become a lot more like the Boston apartment market. So in the Boston apartment market, where I started in this business, the tenant almost always pays the fee, which is usually equal to 1 month's rent. But that is variable based upon market conditions. And there is a time during the year, which is actually right about now, where the landlords say, oh, 2/3 of the apartments flip over on September 1st. Oh, look at our inventory. We've got way too much inventory. We're going to start to pay the fee. And all of a sudden, there's a lot. You can now rent an apartment and get a better deal. Of course, if you wait this long, usually the really good apartments are gone. Yeah. It's called the free market. So I think we're kind of moving towards that. Now, a lot of people out there, Mr. Lamaki and others are going to say, that's going to really hurt buyers. That's going to really hurt buyers. Hey, let me just say that I think it's a better world because the current system we have inflates commissions. I don't think it's a perfect world. I don't think there is any perfect world. But a world where we have commissions that are not inflated by a cabal is a better world. All right, let's see if we have any more comments here. We do not. But we do. Hold on. Prime cash buyer agents, flat fee. Oh, I already mentioned that one. Okay. Sharon, how are you? Great to have you. William says, Friday nights are a good night to go live. Everyone is off from work. Yes, I hope so. And also you get the West Coast contingent, right? Because when I go live at 8 o'clock in the morning or 8:30 on the East Coast, those West Coast people, they're still sleeping, right? So anybody else, comments, questions, concerns? Again, the real estate news article is linked in the description. The joint statement is linked in the description. It's a Google link. And I think that's it. I think there's a lot of moving parts. If you thought that this story was wicked over, or let me see if I can say that more correctly, wicked over, as we would say here in Boston, yeah, you got another thing coming. If you think that this is actually going to happen on August 17th, exactly as it was rolled out to us when the huge media blitz happened, when the New York Times dropped that story, I don't think so. Especially if you're in Massachusetts and you're an MLS Pin subscriber, there seems to be several more shoes to drop. Well, all right, we're going to keep you posted. Thank you so much for joining us. It's been a really interesting week. I knew it was going to be an interesting week, and we'll be back at it next week. All right. I think we actually, if you look at this thing, just bring this up here. June 28th seems to be some type of deadline for the plaintiffs to file a supplemental motion. Whatever it is, I'll be keeping a close eye, and I'll be keeping you posted on this channel. Have a great weekend. Go make some money. Bye-bye.